State versus Loyd. Mr. Loyd is not present. He has waived his presence at this charge conference. For the record, State.
Ryan Williams and Rich Buxman for the state of Florida, Your Honor.
Defense.
Terrence Lemon on behalf of Mr.
Okay. All right, let's start with the jury instructions, folks. Start with the preliminary jury instructions. Did you get the ones I just sent you all?
Like recently, within the last hour or so?
Yep.
Yeah, I got those.
Yes, Your Honor.
State, you get those?
We did.
All right, State, you sent some proposed instructions. What's your argument for yours, if you want to make one?
Briefly, my review of the instructions that the court circulated is that they're relatively similar to the state's proposal, with the exception of the recommendation language. Is Your Honor prepared to hear that issue now?
Yes, go.
The state's argument on that, Judge, as we discussed during voir dire, when we provided the court the decision in Allen, that's ALLEN versus State, 322 Southern 3rd 589, specifically at page 597 to 598, and that's a Florida Supreme Court opinion from 2021, where the Supreme Court indicated that there was no error in the state in its opening statement, opening penalty phase statement, referencing the fact that the jury would be making a recommendation. I went back and looked in more detail at the opinion in Allen, which my computer does not now want to open, but what I do vividly remember from viewing it is the Florida Supreme Court saying that the jury, they didn't use the word entitled, but there is no issue whatsoever with providing the jurors with an accurate view of their role in the process. So I can imagine reasons why the court would not give that instruction. However, we do believe, and at some point today probably we'll ask the court for permission to give the jurors the understanding that we have as to what their role is. And the problem with us doing that when it's not in the instruction is I think it creates confusion. When I think everyone in this, well, not defense counsel, but I think the court's previous rulings indicate that our statement about the law and that their role is to make a recommended sentence and that Your Honor does have to give it great weight is accurate, according to the Florida Supreme Court. So the problem that we have in not giving that instruction is that it will be inconsistent with not only, well, it doesn't give the jurors an accurate view of their role, and it also would be inconsistent with any statement that we make if a court permits us to do so.
Okay. Mr. Lenman, you wish to respond to this?
Yes, Judge.
Just as to the jury instruction right now?
First of all, Judge, if you look at that case, it's clearly a discretionary issue for the court to decide. When looking at this in terms of discretionary, Judge, the court actually needs to look first at what is the lawful forms, what is the lawful jury instruction. And to this day, the lawful jury instruction, even as pointed out in Poole, is the one that exists now. It has not been changed. That does not include any language of recommendation or advisory. As a matter of fact, they intentionally marked it out when they were going through those advisory. If you look at the jury instructions from 18 that I sent you, they can clearly mark out advisory and leave it out intentionally, Judge, because they do not want to underscore the jury's value in believing that it's their decision alone to vote for death or life. So I think that in terms of advising the jury, besides Caldwell and all the things we've objected to before, that I think it's inconsistent with the jury instructions as they exist now and the law, 921-141. Although they say advisory, when the committee originally prepared those jury instructions, they had the statute in their hands and completely decided not to include it. So when it went up to the Supreme Court for final decision, there was no advisory language. Thank you, ma'am.
Thank you. As to the jury instructions, and I'm going to stick to those right now, again, just to keep the record clear. I'm not going to grant the state's request to read the advisory for several reasons. I do agree with the state that the Supreme Court seems to use the word advisory in opinions since Poole, actually. They used it in Poole and they used it since then. But it's not that the instructions haven't been changed, the jury instructions, because as I've said before, I think the jury instructions, it's my job to make sure they conform to the law as it exists right now. But what I'm concerned about is that I have, and I shared with you all, the preliminary instructions, 7.10, from the steering committee, and they don't use the word advisory. And these are quite extensive revisions. They've been tentatively approved. And that might change, and the Supreme Court might tell us that we should put advisory in the instructions, but we're already making changes. I'm just not comfortable because I'm not seeing any indication that the case law is translating into the instructions being changed. So I'm going to deny the state's request to use the term advisory in these. And I'll tell you that rule is going to apply to both final and preliminary because you used it in the preliminary ones also. I saw that you had filed a copy of your proposed ones in the court file for the record, correct, Mr. Williams? You all can remain seated during this.
Thank you. Yes, we did.
All right, great. All right, so let's start with the preliminary, and I'm just going to use mine only because I took out the advisory stuff because I knew you had one with advisory, so I wanted one that wasn't. We're just talking about 710, preliminary instructions and penalty proceedings. Any objections to page 1? These are tracking in many instances, and the state did also, I have to say, track the existing instruction throughout most of it. There were some changes I made and you made, so I'll give both of you a chance to read page 1 and tell me if you have any objections to page 1.
Sorry, Judge, one moment.
No problem.
Judge, I don't have it in front of me, but I've looked at it, and I will voice what my belief is.
Which is?
Essentially, Judge, if you recall, some time ago, before the trial, the state had filed a similar motion and requested jury instructions. At that time, for whatever reason, compared to this time, the two things that they were seeking to remove was sufficiency and beyond a reasonable doubt when comparing, and that's my understanding of what was taken out in these instructions. That was my belief that you took those two out.
And here's what happened so that the record is clear. And I'm comparing this to the existing 710 preliminary instructions. On the first page of the proposed preliminary instructions, the draft that I sent everyone, if you look at the third paragraph, number 2 takes out, I'm sorry. Hold on. Whether each aggravating fact, number 1 is whether each aggravating factor is proven beyond a reasonable doubt. Number 2 is it's just duplicating number 1. That's just, I don't know where that came from, but we need to take it out. Or whether one or more aggravating factors exist beyond a reasonable doubt. That just seems to be a restating of number 1.
I agree, Your Honor. I believe we left it in there because that's the way it reads in the proposal that the committee had, if I recall.
That's the committee's, but not the current one.
Yes, Your Honor. So, but the state agrees that 1 and 2 are duplicative.
1 and 2 read the same to me. 2 reads whether one or more aggravating factors exist beyond a reasonable doubt, which is what we just said in 1, whether each aggravating factor is proven beyond a reasonable doubt. I don't think we need to say it twice.
So the court is clear on my objection. I've filed 2 defense, the preliminary and the final instructions. I filed those. They are the 18. I just took the 18 material and filed those right from the 18 material. So my proposed instructions are consistent with the ones that exist now.
Correct.
So I would be
the
objecting to anything other than those.
Okay, so I do not believe, and this is my position, so I'm not going to keep repeating it. The court is charged with making sure the jury instructions conform to the existing law in the state of Florida. I remember when the insanity instruction got changed by the Supreme Court, and they didn't change the instruction for months. And judges had to change the insanity instruction and were affirmed for changing it to comply with the opinion that the Supreme Court had issued. So the jury instructions often lag behind the court. The existing law in the state of Florida is Poole. And Poole says you got to prove the existence of an aggravating factor beyond a reasonable doubt. It does not require sufficiency, outweighing, none of that Hurst required. It doesn't require that to be proven beyond a reasonable doubt. Hurst had all four. Poole has one. The statute, which is also the existing law in Florida, does not require, the plain language of the statute only requires the existence of the aggravating factors to be proven beyond a reasonable doubt. So between the statute and Poole, I don't believe the state is required to prove sufficiency or weight beyond a reasonable doubt. Now, the statute does require you all, does talk about sufficiency, and we need to talk about that, because the statute and Poole are different from one another. And Poole did not find the statute unconstitutional.
Judge, we agree, we understand your position, and we
Yeah.
agree that 1 and 2 are duplicative. The state's suggestion would be that we eliminate number 1 and make number 2 number 1, and that number 1, the new number 1, read, whether one or more aggravating factors have been proven to exist beyond a reasonable doubt.
Preserving the objections that you've already made to this, Mr. Lenneman,
Yes.
do you have an objection to that specific language?
Judge, I don't have that. You're talking about there?
Mine, I emailed it to you.
No, I know.
Where's your computer?
I didn't bring it.
I don't know what to do about that.
I apologize, Judge, but
Okay, so tell me again what your language is. Since you guys have to produce this, you can go ahead and, I take it, Mr. Buxman, that you're today's scribe?
That's my role, Your Honor.
All right, go ahead. What did you just say?
So my proposal, the state's proposal, was to combine 1 and 2, because 1 uses the word proof and 2 doesn't.
I have no problem with combining those two into one rational instruction to the jury.
So the proposed language was whether one or more aggravating factors have been proven to exist beyond a reasonable doubt.
Do you have any objections to that?
yes.
What's your objection to that?
The instructions the court should
No. Preserving your original
okay.
objection, do you now have any further objections? Knowing that I've overridden your original objection, do you have an objection to this language?
Yes.
What is it?
It's the same objection, Judge. No matter what language you put in, I mean,
Okay.
I don't think I have a secondary line to say, okay, I object, but that's okay. I have to continue to object to preserve.
Okay. So one will become whether one or more aggravating factors have been proven to exist beyond a reasonable doubt. Is that what we just said?
That, yes, Your Honor.
Okay. And so that becomes 1. Then, let me look at the original. So the original jury instructions, the existing jury instructions have as number 2, whether the aggravating factors found to exist beyond a reasonable doubt are sufficient to justify the imposition of the death penalty. And for some reason, when I copy-pasted, I didn't copy-paste that one over. I'll hear the state on this one, but the statute talks about sufficiency. If I can just find what I did with my statute. Go ahead, I'll look while you talk.
Yes, Your Honor. I know what Your Honor is referring to. We don't have an objection to that language. It's the objection to it being proven beyond a reasonable doubt or unanimity. but we agree that it is appropriate based upon the statute that the sufficiency language be included.
Okay, so put back in whether the aggravating factors are sufficient to justify the imposition of the death penalty. The language that's currently, it says to exist, the aggravating factors found to exist beyond a reasonable doubt are sufficient to justify the imposition of the death penalty. Do you have the original 710?
No, Mr. Buxton is writing it.
It reads, whether the aggravating factors found to exist beyond a reasonable doubt are sufficient to justify the imposition of the death penalty. So I don't believe that language requires you all to prove it beyond a reasonable doubt. And neither does the statute.
Whether the aggravating factors found to exist beyond a reasonable doubt are sufficient to justify the imposition of death.
Correct. So then 3 is the one that is in the instruction, whether mitigating circumstances are proven by the greater weight of the evidence. 4 is whether the aggravating factors outweigh the mitigating circumstances. And 5 is whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. The remainder of that paragraph conforms to the existing preliminary instructions. Okay. Okay. And defense has an objection just because we made a change.
Correct.
Correct. All right, so page 2. Is a standard to guide the jury in making the choice. This is the one where I took out the advisory language that you all had put in and reverted to 710. This tracks the existing language. Any objections state other than your request for the advisory?
No, Your Honor. I do believe you also included a bolded sentence near the bottom. Should you find sufficient aggravating factors?
I haven't gotten to that one
Okay,
yet.
but-
I'm just doing this a paragraph at a time because of Mr. Linneman's objection.
Yes, Your Honor, no objection.
All right, so Mr. Linneman, this paragraph tracks the language of the original 710. So I'm assuming you have no objection to it?
No objection.
All right. Do you have any objections to paragraphs that track the original language of 710 with no additions or deletions?
No, only, no on its face, but only to the confusion, inconsistency as it's rewritten under whatever new process that you're writing.
Okay. So the next paragraph, I think, tracks the language specifically. Since I made changes, I'm going to have to do this paragraph by paragraph.
That's fine. We understand, Your Honor.
Yeah. So I think the next one, any objections from the state to the next one?
No,
You
Your
must
Honor.
unanimously agree? Okay. That one tracks the language. Defense's objections have been stated previously. The next paragraph, I think both of us track the language. State has the burden to prove each aggravating factor beyond a reasonable doubt.
No objection, Your Honor.
Okay. A reasonable doubt may arise from the evidence. You should find that an aggravating factor does exist. Okay, the next one is the standard. All right, the next one is a change that you all made. Before moving on, you must determine, yeah, you took out the sufficiency paragraph. Mr. Williams?
I'm looking at Your Honor's proposal. Oh, maybe I'm not.
Well, actually, I missed it when I was doing the copy-paste.
Okay. What is the language at Your Honor's
I'm talking about in the original
7.1?
7.10, after the second a reasonable doubt as to the existence may arise from the evidence, blah, blah. That one, the next paragraph in there that neither one of us put in here is before moving on to the mitigating circumstances, you must determine that the aggravating factors are sufficient to impose a sentence of death. If you do not unanimously agree that the aggravating factors are sufficient to impose a sentence of death, do not move on to considering the mitigating circumstances.
Yes, and it was the unanimity requirement that we objected to and why we removed the paragraph. And I do not believe it should be included because that language is already included in the first paragraph in the numbers that are describing the process.
All right, this is where the statute becomes a problem. Because the statute is also the law. I'm citing to 921.141, subsection 2. And then, well, it's 2A. It says unanimously finds at least one aggravating factor. The defendant is eligible for a sentence of death, and the jury shall make a recommendation to the court as to whether the defendant shall be sentenced to life in prison without the possibility of parole or to death. The recommendation shall be based on a weighing of all the following: whether sufficient aggravating factors exist, whether aggravating factors exist which outweigh the mitigating circumstances found to exist. That's B. And then C is based on considerations in sub-paragraphs A and B, whether the defendant should be sentenced to life imprisonment without the possibility of parole or to death. So you're saying that even the statute doesn't require unanimity?
Correct. Or reason, beyond a reasonable doubt. The state's reading of that paragraph is that that paragraph instructs the jurors as to what they must consider and how they should, what they must weigh when reaching the ultimate decision as to whether death is appropriate.
I disagree on that.
Why?
Because the word use of sufficiency, should you find sufficient aggravators do exist to justify the imposition of the death penalty, it will be your duty to determine whether aggravating factors that you unanimously find to have been proven beyond a reasonable doubt outweigh the mitigating factors. So the paragraph above that clearly states, before moving on to mitigating circumstances, you must determine that the aggravating factors are
That's the paragraph we're talking about.
right, sufficient to impose a sentence of death. So the jury instruction clearly includes sufficiency as part of the requirement.
Let me backdoor into this a little bit. Here's the concern that I have. Let's say the jurors are back in the jury room and 12 of them have found 3 aggravators exist. They all agree on that. But only 10 of them agree that those aggravators are sufficient to vote for death. How can they go on to vote to weigh mitigation and do the weighing process if 2 of them have already said this isn't sufficient to impose death without having weighed the mitigators? So I'm looking at it from a practical standpoint. You understand what I'm asking you? So you
I
got
do.
2 people back there going, I don't think this is sufficient to impose death. That's not a unanimous vote for death. That's what keeps hanging me up, because the language in the statute does not use the term unanimous as to sufficiency, but it uses it in context with, you know, the unanimity that a jury must hit. And so I'm back in my office thinking, all right, I have 10 jurors saying this is sufficient and 2 saying it's not. We're done.
Right, and I think what Your Honor is highlighting is the gap between the statute and the opinion. But what I think the state's position would be, we don't believe you can tell them they have to be unanimous on that, because the Supreme Court specifically said They don't have to be. But it doesn't really matter because if two of them think that it's not sufficient in and of themselves, they're going to reach that conclusion with their last vote. Right? Because the sufficiency is part of the weighing process.
No, but you're missing the part of the next sentence says, if you do not unanimously agree that the aggravating factors are sufficient to impose death, do not move on to consider the mitigating circumstance. That is a clear roadmap on that issue.
I will note, for what it's worth, it was taken out of the proposed new instruction, unless I missed it in the proposed new instruction.
It was taken out.
It was taken out because the poll opinion does actually say they don't have to be unanimous on that.
Right, but here's the issue, Judge. I think you're missing this issue. You're assuming that these instructions are going to get passed.
No, I'm not. I'm using them sort of as a guide, but go ahead, I'm sorry.
You're
Yeah.
assuming they're going to get passed. But historically, as Mr. Dimick told me last night, there are circumstances where they've tried to do things and could not agree. And as a matter of fact, they're at a place right now that one of the individuals who's on the committee doesn't even want to talk about them. And I think he was one of the ones who was originally behind these instructions.
Yeah.
So this is the circumstance. And I know for a fact that they have brought in outside experts before on various issues involving the death penalty and presented information to this committee. So I think that this track that the state is talking about may not and probably won't happen because of various reasons.
You know this can all, never mind. We're just all speculating on what they're going to do next, because it doesn't all have to come from the steering committee.
And
But you're
Judge-
right, they may never agree on this. It can go to the rules committee, and the rules committee can send it through.
Or not.
Or not, you're right. I'm just looking, again, what I told you was, I was using the steering committee instructions, more as a guide as to whether there's an acknowledgement of the changes that Poole made. And the fact of the matter is, the Poole decision changes what we were doing. I can't get around that. I wish I could, because it would be so much easier for me to say, we're just going to use the existing instructions and go from there.
And you may be correct when the time is right. It is not right now because the legislator nor the Supreme Court have approved new instructions. We are still in the old instructions and the statute.
And if that were true, everyone who changed the insanity instruction would have been reversed.
But insanity wasn't based on a constitutional premise that was decided by the U.S. Supreme Court when they reversed in Florida on the Hearst issue. The insanity issue was not that way at all. It was a political movement that it was going to be too easy for people to get off in insanity.
The
and they decided
underlying
to make the
reason why
change.
it happened is not the issue. The issue is that the trial courts are charged with telling the jury what the current law is, regardless of whether the jury instructions have caught up or not. That's the point. And trust me, Mr. Lenneman, I would prefer not to be in this position. I would prefer
understand,
to
Judge.
say, we're just using the existing instructions. But I don't believe I can simply ignore the Florida Supreme Court telling us this is the law in the state of Florida, and it does not require unanimity on sufficiency, although from a practical standpoint, it doesn't make any sense. Because if you don't have unanimity on sufficiency, there's no point in going through the mitigators. You don't have a unanimous vote on death. It's kind of a circle I'm in here.
The only way to square the Supreme Court's decision is to conclude that they found the sufficiency of the aggravators and rolled it into the weighing process.
And what rolled it into what?
To the weighing process, which is pretty much what the statute does.
Well, and I think that's why I didn't put this paragraph in, because I did this yesterday and then did it again this morning.
Yes, Your Honor.
It's
And
why I
that's why we
took it
left it.
out, was because of Poole.
One more point, Judge.
Yes, sir.
I understand that you have an individual responsibility to follow the law as you see it. But as I sent you last night, every other court who's handled a death penalty case since Poole have written instructions consistent with the current ones.
I'm aware of that.
Yes, ma'am.
I have all of those instructions. I had them before we started.
Yes, ma'am.
I went and got them all to see what other courts had done. And I can only make the decision that I think's the right one. And I guess either the Fifth or the Supremes will let me know whether I was right, depending on what the sentence is. I don't know what else to tell you other than I believe that I have to acknowledge the change that Poole made. And if I'm wrong, some appellate court's going to tell me. Let's skip down to the paragraph that I did that says, should you find at least one aggravating factor is proven. This got changed from the original.
Yeah, I think you're talking about the paragraph where it says, should you find sufficient aggravators factors do exist
Right.
to justify? Is that the one you're talking about?
Outweigh the mitigating circumstances, yeah.
Yeah.
Yeah, because you guys added some things in here when I was doing the copy paste. You added the victim impact here. Once the state has presented evidence of the existence of one or more may be presented, victim impact must not be considered by you.
Yeah, and it's my position, Judge, can I speak?
Yes, sir.
It's my position, Judge, that they intentionally put that right after the last line of the upper paragraph where it says, however, if you have no reasonable doubt, you should find the aggravating factor does exist. And then you go right into this issue about victim impact and what is provided by law. They took that completely out of context because they want to confuse the jury that victim impact may be something that they consider. And that's why they put that paragraph right above it, because it was taken out of order, Judge.
Well, it's not actually, victim impact is not in the 710 instructions, it's in 711. This has been added from the 711 instructions. This is not in the original 710 instructions. The current 710 instructions does not, unless I'm missing it, does not contain a reference to victim impact.
In preliminary, you're right.
It does not.
You're right.
Yeah,
Note at the end of that instruction, it says the judge may instruct on victim impact.
right.
Right, and so what they do is they track the language to follow that, and then the next paragraph after that is they completely leave out that the word individual in that, because they're trying to mislead the jury based on the original, because even, this is why I said in my email, Judge, that this is more disturbing than on the surface of Poole instructions, because Poole instructions don't hide behind, the proposed Poole instructions don't hide behind and try to combine things to make them, a favorable result by the prosecutor. And they track it. If you follow the language of the proposed Poole instructions, they're just like the case. They did something different, Judge. They took things they want and left things out and try to, like the individual issue in the bottom paragraph that starts, should you find at least one aggravating factor? They took out, Judge, that the last line of that paragraph in the standards read, rather, whether a mitigating circumstance has been established is an individual judgment by each juror. They don't include that language in that paragraph. They delete it completely. And it's there.
Yeah, I saw that.
Okay.
I'm going to put it back in. So where would you put the victim impact instruction?
Well, I would follow the preliminaries and not include in the preliminaries, because you're not giving details. You're not going through the aggravators or the mitigation or anything like that. This is a preliminary instruction. You're just telling them how this is going to proceed and the general instruction, how it applies.
So let me play devil's advocate with you for a moment, which is this. So I give them no instruction on victim impact testimony. I've given them all this instruction that they're going to hear aggravators from the state, they're going to hear mitigators from you. I mentioned nothing about the fact that victim impact is not an aggravator. They hear all the testimony. They haven't been instructed, put your pens down because this doesn't matter. And then after they've heard all the testimony and potentially considered it as an aggravator, then I tell them not to consider it as an aggravator.
Right.
So
and-
I'm playing devil's advocate here.
Okay, and so I'm playing back with that. I don't have a problem with the court finding a place to put it that's reasonable and fair. What my objection to is Mr. Williams, who initially said he was going to only add 2 things to his objection and instruction, and actually that was a hearing held and that was a motion granted. And so now he comes back, which is very suspect about how this is all going on with the committee. Now he comes back with a whole new set of objections that are...
Okay, here's what I'm going to do. I'm going to move, not because of that argument, but what I'm going to do is I'm going to move that paragraph, once the state has presented evidence, move it to the top after the first paragraph that says an aggravating factor is a standard to guide the jury in making the choice between recommending life in prison. It's the very first paragraph on page 2. You see that? Just move that paragraph right after it because I'll tell them what the 2 things are that the state's going to put on, one after another. And then we'll talk about aggravating factors. And then what I'm going to do is take out the before moving on to mitigating circumstances, you must determine the aggravating factors are sufficient. If you do not unanimously agree, because the pool decision says they don't have to unanimously agree on aggravating factors in the statute. The plain language of the statute does not say that. So I think, though, then we have to use the next paragraph, which says, should you find sufficient aggravating factors do exist to justify the imposition of the death penalty, it will then be your duty to determine whether the aggravating factors let me see how that reads. Let me pop this up. Oh my God. I'm giving myself a headache.
So I'm not following you on the, which paragraph you're talking about.
I'm still trying to find the,
Okay.
I got to find where I put these. I don't think anybody followed what I just said. Did you follow it, Mr. Bucksmith?
I think I have. I think
Great. What did I just say?
those instructions that you sent us, there's a bolded sentence in that paragraph.
Yeah, that paragraph needs to revert back to the original language.
Except for the
Yeah, I'm not,
sufficiency language, correct?
correct. Hold on. No, here's what I'm going to do.
And our proposal, I think, was should you find at least one aggravating factor proven beyond a reasonable doubt, it will then be your duty to determine whether the aggravating factors which we unanimously found proven outweigh mitigating circumstances.
Judge, that's where they leave out
Yeah, that's not.
the individual judgment by each juror. I mean, it says, unlike oh, okay, that's wrong, I'm sorry.
You're winning this argument, Mr. Linneman. You
Okay,
don't-
good
You
to
don't
know.
have to keep making it. Yeah. Let me do the changes here in front of me so I can see what it is that we're changing. Come on. Oh. Enter tab. Oh, jeez. me take this out. So the way the instruction reads, the original instruction reads, is after reasonable doubt, it says, before moving on to the mitigating circumstances, you must determine that the aggravating factors are sufficient to impose a sentence of death. I don't have a problem taking the word unanimously out of that sentence and saying, if you do not agree that the aggravating factors are sufficient to impose death, do not move on to consider the mitigating circumstances. Because if they can't agree they're sufficient, then it's a life sentence. State. I know what your objection is, which is I shouldn't take out the word unanimously.
No objection.
Mr. Linneman?
Yes,
Okay.
Judge, that's correct.
Okay. So that's the original language. I'm trying to make as few changes as possible to track pool. All right, so then the next paragraph that should come up, tell me why you all took out the standard paragraph that says, should you find sufficient aggravating factors do exist to justify the imposition of the death penalty, it will then be your duty to determine. Why did you all take that paragraph out?
The draft that I sent to Your Honor was based upon the committee,
The committees?
and the committee changed that language.
Yeah, they did.
So, and I'm remembering why, because I agree with Mr. Linneman that the last sentence of that paragraph, rather whether a mitigating circumstance has been established is individual decision. I'm pretty sure the committee took that out, and I tracked their language.
They did. But like I said, I'm trying to make as few changes as possible with it. And I appreciate what you did, and I may not have been clear about what I was using these for. I'm trying to make as few changes as possible.
I'll short circuit it for Your Honor. We
Yeah.
have no objection to
Yeah.
the standard 7.10 mitigating circumstances paragraph.
Great, let's put that back in then. Thank you, because I'm really tired of talking.
Understood.
Okay.
There was a suggestion that I removed it intentionally, and it was just tracking the language of the committee proposal
Oh,
is why it was
Yeah,
done
I
the way it
wasn't-
was.
I wasn't thinking you did it intentionally. Okay. So if you can put back the should you find sufficient aggravating factors, that would be great. Mr. Buxman, I'm up here trying to track it also, just to get everybody to that one.
First paragraph, should you find sufficient aggravating factors to remain as is?
Yes, the way it currently exists in 710, because I don't find anything in there that violates pool.
Judge?
Yes,
Can I
sir.
speak?
Yes, sir.
In the next paragraph, they exclude in the current instructions, it says it can be anything, and in the life of the defendant is crossed out, which might indicate that the death penalty is not appropriate for the defendant. They leave anything in the life of the defendant.
All right, let me look at that. You talking about the one that starts a mitigating circumstance?
Yes.
Is that just you tracking the language of the committee?
I would say, however, that the case law does not support that use of the word "or life," because as Your Honor has noted in the past on other topics, mitigating circumstances go to the character, background, or circumstances of the offense. And the example I would give, Your Honor, is the one Ms. Miller used about a smile between the defendant. That's not a mitigating circumstance under current Florida case law.
I would agree with you that a smile between the defendant and his mother is not a mitigating circumstance.
But we are not so upset about the "or life" language that we're going to object. I'm just pointing out
Okay.
that.
So we'll put it back in, just because it's in the standard right
Yes,
now.
Your
I
Honor.
did note that the committee took it out. The
Yes,
committee
Your Honor.
changed this entire paragraph, actually.
We agree, they
Yeah.
did.
So that paragraph is going to be the original from these original jury instructions, correct?
Yes, sir. It can be anything in the life of the defendant. It's in mine. It's in the copy I sent you all.
Yes, ma'am.
Okay. And then the rest of it is just the standard. Correct? All right. I'm going to print what I think that this is supposed to look like, and let's compare notes here. I would email it, but someone didn't bring their computer, so I'm going to print it.
I had some vision this was going to be short, but I was wrong.
And we're just going to do a very preliminary discussion of the final instructions. And then I want to get to a couple of matters, including the motion for reconsideration, because that affects what folks can say and not say in openings, which you all have to do tomorrow morning at 8:30.
And so just we're clear that the last paragraph the state uses, you're excluding completely.
The last paragraph, what?
That the state uses in their preliminary, the last two paragraphs, you're excluding completely. Because that's not even in there.
Oh, you're talking about, did you guys change the last paragraph?
They added two paragraphs, Judge. They're talking about you should not form any definite or fixed opinion until you have heard all the evidence, the argument of the lawyers. There's nothing in that in the penalty phase instructions.
There's not, but do you not want me to instruct them on that, since I've been
Yes,
telling them all
Judge.
along?
Yes, because there could be some point in anybody's testimony where they go, all right, that means more to me than death.
But the rule clearly says that you have to wait until the end. I mean, are you saying that the law in death penalties as to jury considering all the evidence is different? That they can stop listening to evidence
Yeah,
at any
there's
point?
nothing in these instructions that say you have to wait till the end.
State?
Your Honor, we included that language because the committee included that language.
Yeah.
And it's the state's position that it gives the jurors an understanding of what they're going to do and restates the law as to them holding off judgment on a decision. So we would ask the court to include that language,
We object. obviously.
acknowledging it is not in the standard 7.10.
I just don't see any harm in telling them what the law actually is, which is that you have to, we told them this over and over and over again in jury selection, which is you're not to make any decision until you've heard all of the evidence,
And
so.
and they have a lot of misstatements of law. The last sentence, your verdict must be based solely on the evidence or lack of evidence and the law. That is ridiculous that they would even think to put that in there in the penalty phase situation, Judge. It's based on their individual decision.
All right, I just closed this out without saving the changes. Good Lord, today's been a long day. Do you have them all?
I think so, yeah.
So, fine, just take out the part about your verdict must be based on the evidence, the law, and the lack of evidence. Which, by the way, is what their verdict is supposed to be based on. Because the law tells them.
And that they can use, doesn't use the word mercy, but that they're never obligated to find a sentence of
Correct,
that.
but
Well, you didn't include that
We'll
in the
take it
last
out.
sentence.
since I don't want to retype everything I just typed, Mr. Buxman, when you get a moment, if you could send me that, that would be great. You can send it to either email. I have both of them up. Okay. All right, take one last look at this, folks, because this is what I'm reading at 8:30 tomorrow morning.
Final copy?
If you email it to me, I can print it.
Okay.
Did you send it to 2?
Yes, ma'am.
Okay. There it is. Do you all want a hard copy of it? You want a printed copy? State?
That would be wonderful, Your Honor.
All right. no
Thank
problem.
you.
Sure. Two.
Thank you.
Here's one more. I actually made each of the state attorneys their own copy. There you go. All right, take a moment to read this. Like I said, I have to read this tomorrow morning. I need a final on this one. And by the way, I'm proposing that I hand them this instruction in writing, not just read it to them, since the penalty phase instructions are a little unusual.
No objection.
Okay, any objections, Mr. Linneman?
You handed it to him?
I'm going to give them the instructions in writing, so they can follow along and have them with them while they're listening to the testimony.
Yeah, only tied to my instruction. I object to this instruction.
Well, I understand you're objecting to the instruction, but having denied or overruled your objection, I'm going to give them a written copy of the objection, of the instructions you've objected to,
Understood.
okay?
There's a highlighted or an italicized word, agreed, on the second page on page 6.
Okay, thank you.
Full paragraph down on page 2.
Okay, I see it. Okay, thank you.
For the italicized word, we have no objection to the instruction beyond previous objections made.
Thank you. Mr. Lenneman, beyond the previous objections
Right.
you have made, do you have any additional objections?
I thought we had, I had pointed out the language of anything
Where?
in the defendant's.
What paragraph are you on?
I'm looking, Judge. I just saw it and then I lost track of it. Hold on a second. In paragraph 1, 2, 3, 4, 5, that starts out, a mitigating circumstance is not limited.
It can be anything in the life of the defendant, yeah. That tracks the current
Okay,
language. This is identical to the current language.
okay, that's fine.
All right. So we have the preliminary instructions for tomorrow. I'm just going to go over a few things, frankly, on the final instructions, because we need to hear the evidence in this case. So I sent you all the proposed ones for the same reasons. I said I denied the advisory opinion language on this one. Let me talk about the aggravating factors here.
Judge, did you, because I never got that one, can you just make sure that you resend it to me?
I sent it to you. I did. You
Because I
were in the
was
same
waiting for
email
it.
everybody else was. Okay.
Okay, thank you.
I'll send it again. Yeah. It wasn't?
Which one?
I just send it to whatever pops up.
No, I don't use it anymore. Can you forward it to me, Rich?
Oh, okay, thanks, yeah. I just send it to whatever pops up on the computer. I don't. Okay. All right, so the aggravating factors that the state, I lifted this from y'all's instructions, that you all are requesting is Markeith Loyd was previously convicted of a felony on felony probation. Any objection to that one, Mr. Lenneman?
Yes, he was not on probation. He was on, I have it written down if I can find it. Oh, I have the letter here. I have the letter from the Department of Probation. He was on supervised release.
That's
That is not
probation.
probation.
That's probation, that's federal probation. He testified that he didn't want to tell his probation officer
This
that
is
he had a
what,
gun.
this is what's in the actual judgment. It says supervised release. So I'd ask that it be supervised release.
State?
The statute says probation. Mr. Shepard, the probation officer, will come in and testify.
Yeah.
We believe supervised release is a synonym for probation, and it should remain as the statute requires.
Over the defense objections, I'm granting this one. You can talk
And
about it in
so
open.
it's clear, Judge, I'm filing as a defense exhibit, August 2nd, 2019, a letter from DeCarlos L. Shepard, Assistant Deputy Chief of United States Probation Office, where
Okay.
he identifies that Mr. Loyd was on
Do you have-
supervised release.
Do you have any objections to this exhibit, State? For purposes of this. All right, this is being admitted as defense exhibit number 1 for purposes of the penalty phase charge conference only.
And so it's clear, I'm not saying that the statute doesn't apply, or the jury instruction, I'm just saying that's the wrong language being
You
used.
just want to use the word supervised release
Correct.
instead. Okay. All right, so
I
number,
have no objection to having it say he was on felony probation or supervised release. It's the same thing, if that makes,
you wanted to say or supervised release?
I wanted to say supervised release, Judge.
Okay, so we'll leave it as felony probation. All right. And again, if the probation officer testifies to something different, these are finals. So this is a preliminary conference. I'm just trying to get you what you can say and not say in openings.
Okay.
Okay, 2, Markeith Loyd was previously convicted of a felony involving use or threat. I took out the mutiny. Any objections to the rest of it?
I think this is capital felony or a felony involving the use or threat of violence.
I copied, all I did was copy paste into your instructions for this, so you left out the word capital.
Mr. Buxton's correct. That's my error because
Yeah.
the murders are capital felonies.
Yeah, I kept looking for the
That's my-
capital, and I didn't see it, but
That's my
I thought
fault,
for
Judge.
some reason you'd left it off. So, all right, so it's a capital felony.
Judge, because I don't have that one, I'm just referencing Mr. Williams. He has, in that particular one, resisting an officer without violence, which
I took that out. We can't hear you. Is your mic up too high? Sometimes it's too high, or
Hello?
not on.
Yeah. And then, Judge, did you include the names of the victims from the Daniels?
I haven't changed that yet. That's why I said, do you have any
I
objections?
do- Well, I do have objections to their names being in there, Judge.
State?
They're put in there for reference so the jury can understand that they're different counts.
All right, I'll take that one under advisement. I don't know whether that makes any difference, putting the name. So for right now, you obviously can talk about who belongs to what count in opening. So for right
ma'am.
now, I'm just circling that as something I need to look at.
Going back to the beginning, Your Honor, I think the second sentence of that, the crimes of battery on a law enforcement officer, I believe he was actually committed resisting with violence. That, not resisting without.
I don't remember what his prior conviction was on that one.
I thought it was bat Leo and resisting.
It may be.
And if it was resisting with, I think that qualifies as.
Yeah, because the one you put in was resisting without, so I took that out. So you want resisting with violence? Because you got the resisting with violence on the first penalty phase.
Then that was it.
No, yeah, you did.
With the bat Leo.
Yeah, with the bat Leo. So you can put that one back in.
I'll
Again,
double
that was
check to
my
make sure
error.
I got it certified.
So we have bat Leo, resisting with violence, first degree murder with a firearm. That's this is Sade Dixon. First degree murder with a firearm, killing of an unborn child by injury to the mother, attempted first degree murder with a firearm, attempted felony murder with a firearm, the victim of that one being Stephanie Dixon Daniels, attempted felony murder with a firearm, Dominique Daniels, aggravated assault with a firearm, and carjacking, which are this case, correct?
Yes, sir.
Okay.
Are we going to separate those two sentences and have one sentence that says the crimes of first degree murder are capital felonies, and the remainder are felonies involving the use or threat of violence?
You can. I mean, you can say he was previously convicted of a capital felony, first degree murder with a firearm, killing of an unborn, killing of an unborn child is a capital felony. Then say, and felonies involving the use or threat of violence to another person, and then list the rest of them. That would be the only thing I would agree to. Defense?
for right now, no objection.
Okay. All right. Number 3, Markeith Loyd knowingly created a great risk of death to many people. I'm not inclined to give you this one. Go ahead. What's your argument?
There are going to be additional witnesses at penalty phase that will be testifying about their locations and about them being in the line of fire, specifically an individual who was sitting in the truck that was shot. At the time it was shot, I believe another person who was also in the parking lot near that area.
All right. So at this time, I don't have any evidence of this, so leave it out of opening, and I'll leave it open for consideration, because the great risk of death cases are very specific.
I believe we will have reached the threshold of, I believe, 4 or 5, whatever the case law requires.
4.
Other than the victim.
Other than the victim. I think
Other than the victim, yeah. You need 4 more, so.
I expect that we will reach that threshold number.
All right, so I'll reserve on that one, but not in openings, okay? You cannot, in other words, you can't mention this one in opening because you haven't got this one yet.
Can I mention that additional evidence?
Yes.
Okay, thank you.
Let's see, number 4, first-degree murder was committed for purpose of avoiding or preventing a law. Oh, I'm sorry. Mr. Lenneman, did you have any other objections to create risk of death to many people? All right. First-degree murder was committed for the purpose of avoiding or preventing a lawful arrest or escaping or effecting an escape from custody. Any objections to that one, Mr. Lenneman?
Yes, he was not in custody.
That's just the way it reads. State, so you want us to take out the words "or effecting an escape from custody" and just have it read "preventing a lawful arrest"?
Correct.
State, you have any objection to that?
No, Your Honor, it tracks the facts of the case.
All right, so we'll take it out.
But as Your Honor noted, that's the statutory language.
Yeah, it's just the statutory language. All right, number 5, first-degree murder was committed to disrupt or hinder the lawful exercise of any governmental function or the enforcement of laws. Any objections, Mr. Lenneman?
Well, there's going to be 2 doubling objections that I have.
Well, those are different.
Okay.
The doubling is noted in here. This is just whether or not we even have preliminary evidence of these.
Yeah,
So-
I think there is.
Okay, so these two are fine. First-degree murder was especially heinous, atrocious, and cruel. What do you guys got? Because, I mean,
We expect to introduce additional evidence specifically from Ms. Pridgeon, who will talk about how she walked up after the shooting to Lieutenant Clayton, that she was conscious, she was awake, she was aware, she was moving her arms, reaching up for her radio, as well as Dr. Stephanie, who will talk about the pain and suffering caused from the initial injuries before she fell to the ground, as well as the length of time it would take her, that after she fell and after the neck wound was inflicted, her heart continued to beat, her chest cavity continued to fill with blood, and he has reviewed the video as well, would indicate that those movements are consistent with voluntary movements in consciousness and awareness.
okay, I'll listen to you, because on its face, with what I have right now, you don't have hack. But if you've got more evidence, I'll reserve on this one. Okay? You can certainly refer to the evidence that you intend to introduce.
I didn't know,
Yes.
you guys didn't list Pridgeon in your witness list you sent.
She testified the first.
Oh,
Okay,
you're talking
let's
about
stick
what
to
you said
this.
here. Okay.
Let's
You're
stick
not
to this,
recalling
and then
it.
you guys can talk about
Oh,
witnesses.
but you didn't have in your list?
Gentlemen,
Sorry.
we're going to stick to this, and then you can talk about witnesses on your own time. 7, first-degree murder was committed in cold, calculated, premeditated manner. CCP, it's a 6-second incident, or 13 seconds.
No
How
way,
long was it?
Judge.
13?
I'm pulling up my outline, Judge.
Okay.
I think the state's request would be that you allow the state to discuss the facts that support it, if not you, but not use the actual.
Right. So that, and I'll allow you to present whatever evidence you're going to present. You can
Understood.
discuss these facts, but do not use the term cold, calculated,
And
premeditated.
remembering, Judge, that if we were to do so and then Your Honor didn't instruct, that would be foolish on our part as well. So we understand.
Okay. Yeah.
Yes, Your Honor.
I just want to be upfront about the fact that I don't see any evidence of CCP at this point.
Yes, Your
Again,
Honor.
if you have additional evidence, it might change. All right.
Yes, Your Honor.
Mr. Lenneman, if you have additional objections to these at this point, you can tell me. All right, and then the last one is she was a law enforcement officer. I don't see anything in that anyone could object to. Okay. Unless you have an objection, Mr. Lenneman, to her, Debra Clayton was a law enforcement officer.
Judge, I think that's the correct statement.
Okay. So the ones that are definite,
Oh,
right?
Judge, I do have an objection.
What's your objection?
They use the word legal, and the actual instruction says official. I would object to the use of word legal.
Did you change the word?
I don't believe so, but I honestly
I always
don't.
thought it said legal duties, but maybe it does say official. Let me look.
No, I think it says official.
It says,
It says official.
yep, it says official. Defendant, or Debra Clayton was a law enforcement officer engaged in the performance of her official duties. So just change the word to official.
Yes, ma'am.
I'm not going to get into the doubling issue. I mean, there are doubles here that are acknowledged. I'm
Yeah,
going to
there's
guess what
additional-
your issue, your issue is the Leo being, the fact that she was a Leo being a doubler of the arrest and flight.
Yeah, I'm pretty sure that, I think it's in Wheeler that they address that.
Yeah, that's going to be an issue we need to address. I'm not going to address it today,
Okay?
but State, you need to be prepared to address. There's some case law that seems to indicate that her being a law enforcement officer is also a doubler to the attempt to escape, or, attempt to flee and attempt to hinder. So I've got that case law out, but that's a complicated discussion I don't want to have today, because we don't need to have it for openings. For the record, I have no idea why that blue highlighted sentence I put in there is in there. So I was doing a lot of stuff at one time, so.
Blue,
Underneath, it may not be blue in what you're looking at, but on page 5,
the bottom.
there's something in there that got highlighted in blue, and it may have been because I was going to take it out and then forgot to take it out. You may not have it. It may be highlighted in red on your copy.
It is.
Yeah, okay. I don't think there's anything else in these finals that we need to discuss at the moment for purposes of closings. We need to get to the mitigation issue, the use of force issue.
Okay?
State, anything else you want to discuss about these prior to closing?
No, Your Honor, I will send the changes I made again to both.
Okay, great. All right. Mr. Lemon, you filed a motion for reconsideration on the use of force, and by use of force, I mean reconsideration. I did rule that you couldn't use Mr. Lloyd's, you couldn't identify how Mr. Lloyd lost his eye, and you couldn't use the videos. You asked me to reconsider that ruling for penalty phase.
Yes, ma'am.
Go ahead.
I mean, it's pretty squared out in the motion that Ms. Miller put together. But
Which is somewhere on this mess right here. Just tell me what your argument is.
our argument, Judge, is that it is mitigation for the jury to consider the injuries he suffered, how he suffered those injuries. And the circumstance would include showing the helicopter footage that you can actually see the beating of Mr. Lloyd, calling Chuck Ashworth, who's already testified, and he'll talk about what he observed after the fact, because he didn't actually see the beating.
What did he observe after the fact? What are you expecting to say?
I'm going to accept that he was the one who was supposed to take him into custody, and he started to. And there was a lot of things that are probably not relevant, Judge, but I got to talk with my co-counsel about. He was being spit on. They were calling him names, various things. They pulled him over between cars. That's when they took the.
Okay, so make the nexus for me between that and mitigation. How are you going to argue this to a jury is, I guess, what I'm asking you. You don't have to tell me your whole argument. Just
that
what is the
they're
nexus?
allowed to consider that.
Because it did what?
Because,
I mean, it certainly does not make the police look good, but that's not the point of mitigation.
because it is a mitigating circumstance which could be considered if proven.
Because it says what to who? What does it say about Mr. Lloyd? How is it connected to Mr. Lloyd? You can't just talk about, I mean, mitigation is not Mr. Lloyd was standing there and someone crossed a light and he observed them cross a light. It's an illegal activity he's observed, so what? It has nothing to do with him. Mitigation's about him, not about the police.
Right,
So-
he suffered this significant injury by the police while he was trying to give himself up to the police.
And that affected him how?
That he has a permanent injury where he lost his eye. He's no longer able to see out of it. He suffers from painfulness, and that, this all affects him on a regular basis. It's mitigation.
It affects him how? You're saying he has pain from it.
He has pain. He's lost the use of his eye. There are things he can't do now because of the loss of his eye. He has a permanent scar, and his eye is closed. And from a medical perspective, he has dealt with a significant amount of pain.
State.
Your Honor, there's two prongs, well, three prongs to this argument. The first one is that the only case law or law period that has been cited to Your Honor beyond what was initially presented was Wheeler. And I went back and looked at Wheeler, and Wheeler references a footnote where a trial court found as mitigating the fact that the defendant had been shot and was paralyzed. The Supreme Court's opinion in Wheeler didn't even address whether that was proper to be found. It just puts it in a footnote. So the law that Your Honor had when you made the original decision has not changed. That's the first thing. The second thing is Your Honor's statement and the inability of the defense to articulate how this impacts Mr. Loyd is telling, because the Supreme Court case law that is cited repeatedly throughout the state's motion in limine indicates that it has to go to moral culpability. That's what the language in the case law uses. And as we just discussed during the prior conversation, it's not supposed to be anything in his life, quote unquote. The obvious reason that counsel, and I can't blame him as counsel for the defendant, wants to introduce this is because it will inflame the jurors and make them upset at law enforcement and give them a reason why not to impose a sentence of death on Mr. Loyd. But it has nothing to do with Mr. Loyd's character, background, or the circumstances of the offense. And all of the case law references that.
Well, let me ask you a couple questions.
Yes, sir.
I listened very carefully to Mr. Loyd's testimony and to the testimony. And remember, I heard the first penalty phase. I know you weren't there, but Mr. Buxman was. I also heard the first penalty phase. This is why I called this back up for reconsideration. Mr. Loyd testified, I think we all agree, not only on the stand, but many of his statements that he has made to the court concern the loss of his eye and how he was treated by the police. And he testified at length about his fear of the police, his beliefs about police and police brutality towards blacks. It has nothing to do with the circumstances of the case. I agree with you on that 100%. And that's why we didn't talk about it in guilt phase. It's nothing to do. However, I'm struggling with the issue, having read further cases, I'm struggling with the issue of whether or not, and as I've said repeatedly, I only want to try this case one time, whether the jury believes that or not, whether or not the jury is entitled to hear, and Mr. Loyd is entitled to testify to the effect it had on him, because they're judging the person sitting in the courtroom today, nowadays, not just the person that committed the crime, but the person he is now. I'm struggling to believe that that beating that he took that resulted in the loss of his eye does not form part of Mr. Loyd's thought process now, his character, and I've kept it out up until now. I've been very limited about this, and I've already said if this is connected to brain damage, it's coming in.
Understood. I don't know any definition of character that would include a fear of police. I don't think that's the term, the way the term is used.
Character may not be the word that I'm looking for, but at the same time, I'm trying not to make arguments for people.
But it's the word that the cases use. That's the problem. And the state even cited to a case, there's a case where a defendant escaped from a corrections facility, and they wanted to admit evidence of, they believed, wrongdoing by corrections officers. And the Florida Supreme Court said, no, that's not admissible. It's not relevant to the character, background, or nature of or circumstances of the offense. And I can find it within.
It's Eaglin. I have that case now.
I know which case. I don't know the name of it because I'm horrible with names of cases,
So-
but I know what you're talking about.
And if I may, because the third prong, Judge, I cannot tell a court how prejudiced this would make the state at this point, given the reliance that we've had on Your Honor's decisions. As you recall, I'm sure, we did not question any of these jurors about use of force, other than in the context of the shooting, right? In fact, we specifically excluded jurors who indicated they had knowledge of that. I think Your Honor has observed our preparation for this, given the circumstances that we were told we would be facing. And we would have asked, I can tell you, hand to God, I would have asked these jurors what they think about a use of force, because that matters. And we didn't have an opportunity to do that because of the prior ruling. We would have gotten a use of force expert that would have been able to illuminate why the force was used by law enforcement. We don't even have witnesses under subpoena who could address Mr. Loyd's claims that this was an unjustified use of force, because it wasn't brought to our attention and that could be admissible. So while I certainly understand the court's position, we have relied wholeheartedly on it to this point. And I say to the court that we do not believe we could get a fair shake in this next penalty phase if this is sprung on us at the last minute. I mean, we're starting tomorrow morning. And we cannot do anything to get ready for that if the court changes its ruling. We would not have sought to exclude it if we thought it was any way reversible. We have known Mr. Loyd's position about this for some time now. I mean, Your Honor can imagine what we would have done. An investigation was done. The jurors would be thrown this information as if no investigation by law enforcement was done. I haven't reviewed the 1,000 pages of FDLE report for the last 2 months because we were with an expectation it will be excluded. And that would all be relevant, because imagine the circumstance Your Honor is proposing. Mr. Loyd gets on the stand and says, they beat me up, they were unjustified, we're stuck.
That's a lie.
Well, can't Mr. Lenneman stop? And I've warned you repeatedly about this. It is unprofessional and it's a violation of the rules of professional conduct to use terms like lie. And it's not your turn to talk.
Yes, ma'am.
Well, Mr. Williams, why couldn't I solve that by doing the following, which is continuing the penalty phase to give you time to prepare for this, releasing the jury from sequestration and ordering them to return for a penalty phase in a week or two. I'm very cognizant of the position I'm putting the state in. I've been struggling with this for a while, and it was the testimony at trial and listening to it that caused me to start to do some research on this. Why would that not solve your problem if I changed my ruling?
Because
I haven't changed the ruling at the moment, okay?
I understand, and we discussed that, frankly, when we got your email. It doesn't solve the problem that we don't know what these jurors think about the use of force.
I agree with you on that point.
And I don't know how to remedy it, because I would have requested individual voir dire on that topic, and I didn't ask a single juror about that issue. So, to be candid, Judge, I think you're on solid ground with the decision you've made, but I don't know of a way of undoing this that is fair to us whatsoever. And I think we are where we are, and if Your Honor has made if your Supreme Court finds or the 5th DCA finds you made a mistake, they'll address it. None of us wants to do it over again, but there's just no way for us to go back on this. There's no way.
Can I respond?
You can now, as long as you do
First of
not
all,
make personal attacks on anyone.
Mr. Williams fails to point to the court of the FDLE investigation that was conducted. In the FDLE investigation, ultimately, there were 4 officers that were exonerated. Those are the 4 officers who were involved in, causing the injury to Mr. Loyd. In addition, there are multiple witnesses that talk about Mr. Loyd turning and doing stuff that they justify as the reason why the officers used the force they did. So they knew that forever in this case. They've known about it. They've been provided all the documents. There was a thorough investigation conducted by FDLE, and they exonerated the 4 police officers. It was public. Everyone knew. And so that is evidence that they can use to deal with, or at least a piece of the evidence that they can use to deal with the circumstances of the court allowing this in. The argument that Mr. Williams makes about, Judge, we can never get a fair shake and all that, this court from the very beginning has never firmly said it's not coming in penalty phase. As a matter of fact, the court walked on the line all the way up to the trial where the court was saying, listen, you're not using in guilt. That doesn't mean I'm not going to decide. So at the time we started jury selection, they knew that. For them to say they didn't do that is not correct. So the other thing, Judge, is that he could have asked anything he wanted in jury selection because he never approached the court and said, Judge, I know you've been talking about possibly allowing this in jury selection. Can I ask some questions? Can I do that? I need to know. I mean, Mr. Williams is very firm when he wants to talk about something, and he has a problem with an issue. But he ignored that in the hopes of this issue would never come up. This would never be a problem. And the court's thought process on this is correct. The things the court has said why the court is troubled is the absolute truth. And so now you're stuck in this situation, and I agree with the court. If they need time to prepare, but I'm telling you, Judge, they make a couple of calls, they got literally there was 30 officers around where Mr. Loyd was. Some of them didn't see anything, some of them saw something, and no matter what was saw, they were all interviewed by FDLE. Most of them were interviewed by the Orlando Police Department Internal Affairs Section, and both Orlando and the FDLE exonerated those 4 officers. And they are witnesses to come in and tell why they did what they did, because in their statements, they justified what they did. And the state has known that all along. As a matter of fact, they listed Officer Cute, who is one of the individuals who was involved in this. They listed him as a witness in anticipation of this issue coming up.
I do have to agree partially with what Mr. Lenneman said, that I did say that some of this was going to come in penalty phase, but I never told you all the extent to which I was considering, because honestly, it wasn't until I heard the testimony at trial that I made the connection between, because it had never been articulated to me before, that I made the connection between Mr. Loyd's mental state and his reaction to losing his eye, which is part of penalty phase and is part of mitigation. I'm not happy about the fact that it's, we're starting tomorrow morning at 8:30. And I do think it's reversible error if I don't let him talk about it. Now, that doesn't mean that I think this is a free-for-all on, the police and, indicting every police officer that ever appeared on the scene and had literally nothing to do with what happened to Mr. Loyd. So I'll let him talk about the loss of his eye, who did it, and I'll let the helicopter video in. However, this is unfair to the state to a great extent. So I'm giving the state the option of putting off this penalty phase. I would have to release the jury from sequestration with a great deal of instructions and bringing them back in a week or two to give you time to get everything reworked and get your witnesses here to deal with this. Because it is, I mean, I had said from the beginning he could talk about it in relation to his brain damage, but I looked back at my orders and I specifically said he couldn't identify how he got the injury, which is the big problem for the state. And I'm not happy with the fact that I find myself in this position, but I have to rule the way I think the law requires me to. So, Mr. Williams, Mr. Buxman, take some time, think about what you're going to do. If you want to go out in the hall and talk about it, go out in the hall and talk about it, come back in and tell me what you want to do. You're winning this, Mr. Lemon. Just let it go.
Okay.
Two positions from the state. The first is that we certainly need time, and Your Honor, we need more than a week to get this done.
Well, I'm not going to disagree with you. I've never done this before. I'm a little uncomfortable
Honor.
with having to do this to y'all, so.
I think December is the earliest, and I think the first or second week in December. The second thing, assuming Your Honor grants our request to continue, is it's our intention, we have to do some research to move for a mistrial as a penalty phase.
On the penalty phase?
Because I don't believe, I was honest when I said, I don't think we can guarantee ourselves a fair shake with the jurors we have having not been questioned.
Mr. Williams, you do what you need to do.
Yes, Your Honor.
You know what my reaction is to legal motions, which
Yes,
is,
Your Honor.
you all do your jobs, do what you need to do.
That's just me giving Your Honor a heads up,
Sure.
and we'll do that sooner rather than later if we can, because obviously jurors are going to be hanging out and that, but I mean, he's been convicted and adjudicated of first-degree murder at this point.
Well, and I'm perfectly comfortable with me leaving all of that out in the guilt phase. It had nothing to do with whether or
Right.
not he killed Lieutenant Clayton. It was totally irrelevant.
So that's our position as of right now.
State,
I think defense judge.
oh, defense, I'm sorry. You're the state.
Whatever-
Defense, Mr. Lenneman.
Whenever the court picks, I'll have to reschedule everything, Judge. So it's up to the court. I have no objection to a continuance.
Well, I do think that the state is right, that it's unfair to them for me to make this big of a change in the ruling. This is not a minor change. This is a fairly large change. Although I did tell them that I would admit some of it in penalty phase, I never said I was going to let the video in, and I never said I was going to let them identify what happened. And again, like I said, this is all based on what I heard during the guilt phase and some further, I became uncomfortable with it, started doing some research about it, and saw a nexus there that I had never seen before, a potential nexus. It's up to the jury whether they believe there's one or not. So I think the state's request for a continuance is more than well taken.
I have no objection to the continuance. However, I am strenuously arguing that this court never took the penalty phase off the table with this issue of use of force. I think if we go back to transcripts of 6 months, 8 months, 10 months, that this has been on continuously. The court said, no guilt, penalty a possibility. I have to think about it. I'm not sure what I'm going to do.
Well, since you're not objecting to the continuance, what difference does it make?
I'm ready, getting ready for their motion, Judge.
What motion? They haven't filed anything yet. I just dropped a bomb on them that they need time to absorb and think about, and they're just being courteous and letting me know that they might file a motion. All right, so here's what we're going to do. You're going to bring the jurors in tomorrow morning. I'm going to inform the jurors that there have been some developments in the case that mean that we can't go forward the penalty phase right now, that I'm going to release them from sequestration with 5 million instructions on what they can and cannot do, and then I'm going to schedule this. I will have a date, unless I can get, hold on. Let me see if I can reach my JA, because I'll give you a date right now. So you want, what, the first week of December?
Preferably the second week of December. The first week of December, I think, is December 1st.
I have no idea. I don't even know what day it is today.
Yeah, the first week of December starts on Monday, the 29th, and then goes into the
Let me
first,
rouse
which is a
my-
Wednesday.
So the technical first week of December is December 6th, and that would be fine. Monday, December 6th. We could make that work. I
Can
had
we
a
do
problem
the whole,
with
what we have to do?
Monday, the 29th.
Can we do the whole penalty phase in 1 week? We can.
Well, Judge, so this is,
Unless
we're
we
gonna-
get to the mistrial part. Yeah, I get
well,
that.
no, I mean, we're going to have to file motions about, I mean, this issue has been adjudicated, and what the court is going to allow from the investigation that comes in, it's gonna be a thing. So I can't promise, Your Honor, that it'll be a week, but I think it will be less than 2 weeks, if that's helpful.
So you're saying the second week of December?
The first week of December, the first full week is Monday, December 6th. Because December 1st is Wednesday, I believe.
All right, let me see. She's on, so let me get her to answer me. Can you two see my dockets there? I can see my own docket, hold on.
While you're waiting for your day, Your Honor, do you have any change in your ruling about admissibility of the interrogation video, images of the defendant afterwards, and those kind of things? I'm trying to narrow down as far as what's admissible and what's not.
Oh, I don't blame you for getting really specific, Mr. Buxman. I think you should prepare for all of that in preparing for another penalty phase, because as I said, my problem has been what the testimony is that I heard was different than what I had heard up until that point as to what could and could not be applicable. I'm inclined to tell you at the moment that while I might allow Mr. Loyd to talk about them not taking him directly to a hospital, I'm not inclined to let that video in because it's very long, and I think the prejudicial impact of that might outweigh any probative value it has. And that's what I'm thinking right now, is that I would let him testify to what happened, but not play the video. And I'm sure that Mr. Lenneman will have motions and things to say about that. Yes, sir.
Perfect. I'm going to file a motion for cost. Can we expedite this transcript so we have it? Because obviously I'm not taking down notes and.
I don't know. I mean, these transcripts are coming out like the next day, aren't they? Yeah, they're coming out pretty fast. You should have it pretty quickly.
Okay.
What? So you're not getting it tomorrow? I don't
Okay.
seem to have a whole lot going on yet that first week in December. My JA might quit, but, oh, that's not a good day. That's a bad day. Okay. She isn't answering me. Let's see. What? No, she answered me. She's looking right now. I just looked. I think I'm clear. I can't wait to tell the chief judge. Therese. All right, while we're waiting for a final, tentatively, we're going on the 6th. I'm waiting for a final response from my JA, but here we go. Are you sure it's the 6th? Yeah, the 6th. All right. So we're going to set this for December 6th. I'm going to bring the jury in tomorrow. I'm going to release them from sequestration with instructions. Since I've released them from sequestration, there's literally no point to sequestering them again during the penalty phase. They're either going to follow the rules or they're not. I do apologize to everyone for the delay, but like I said, I can only do what I think is the law in these cases. All right, so I'll see everybody tomorrow morning at 8:30.
Thank you, Your Honor.
Thanks.
Thank you, Judge.